do have skills that make me a nightmare for people like you.
Ms. Spellman.
Tēnā koutou e ngā komihana. I'd like to call our next witness, who is Judge Andrew Beecroft.
Thank you. Good morning, Judge Beecroft. I'm required by the Inquiries Act to ask you, just as you commence, as follows. Do you solemnly, sincerely and truly declare and affirm that the evidence you will give before this Commission will be the truth, the whole truth and nothing but the truth?
I do.
Thank you. Ms. Spellman.
Thank you, sir. Tēnā koe e te kai whakawā. Before we begin, Judge Beecroft, if I could ask you just to refer to the statement in the folder before you, and I believe it's signed by you on page 16.
Signed and dated.
And could you confirm the statement is true to the best of your knowledge and belief?
I do.
Thank you. Now, before I begin with questions, I understand you wanted to outline briefly the evidence that you're going to give today.
If I could begin, inga mana, inga reo, I tēnei whaitua a tāhua, mihi mai karanga mai, e kurima, e koroma, a tēnā koutou katoa. He pai ki te kororo ki e koutou I tēnei rā. Tēnā koutou katoa. Can I begin by making 6 brief introductory points, which I hope both set my evidence in context and provide a summary of the key issues that my evidence raises. Firstly, I begin by acknowledging the suffering, hurt and violence experienced by the many who have been victims of state care and the abuse they have suffered and the strength and courage they have demonstrated already in sharing their experiences. As the current Children's Commissioner, and as a father, brother and son, I want to acknowledge it as a harrowing experience, as it must be for all of us, to hear about the extent of abuse that children and young people have experienced. And it is particularly hard knowing that the abuse in state care continues today. I need to acknowledge too that as a judge and as a Pakeha male, I come from a position of privilege and have enjoyed a stable and loving family myself. But my current role comes with significant responsibilities and obligations to give voice to children and young people today, particularly children and young people in care, and I want to do justice to that responsibility. Number 2, I need to be very honest from the start to say that since 1989, the Office of the Children's Commissioner has been the independent monitor of both child, youth and family and more recently Oranga Tamariki, with a responsibility to monitor the practices and policies of the state care system. To the extent that that system has failed our children, there is at least, by implication, a recognition that the office has failed to properly monitor the system. And I make that acknowledge carefully and I hope responsibly, acknowledging at the same time that the government has never funded the office to comprehensively monitor those in care, and successive governments, despite requests to do so, have not, in my view, sufficiently funded, in any way nearly sufficiently funded, a state monitoring agency such as myself to carry out the job. And that, in a sense, is a leitmotif that I think will flow through the inquiry, that to have a statutory mandate for independent monitoring is one thing, to resources it and to commit resources to it is quite a different thing, and there has been a wholesale failure, frankly, by successive governments to ensure that its system of care and protection has been adequately, comprehensively resourced to carry out that monitoring mandate. Number 3, In alignment with our statutory mandate, the focus on this submission is based on state care institutions. But all children have the right to be free from abuse. Can I suggest that in pursuing this goal, the Commission will face many difficult issues along the way? One, for instance, is the issue of privilege. That is legal privilege that's asserted. An example is a provision in the Evidence Act that means communications with ministers of religion are legally protected. If someone discloses that they have perpetrated or are perpetrating abuse against a child, such admissions are legally privileged. The issue as to whether this privilege should be abolished is but one example of the issues that this Commission will face, an issue that faced the Australian Royal Commission also. And can I say generally that privilege is a particularly adult concept, usually asserted to protect adults. I hope that privilege is not asserted too often to this Commission, and if it is, I would urge you to examine it carefully as to whether it's really necessary. As I say, it is an adult concept, usually to protect adults, and I hope privilege, wherever possible, can be waived so that children are enabled to have their story told clearly, and what happened to adults as children is told. Privilege, it seems to me, is a peculiarly adult-centred rather than child-centred concept. The fourth thing, by way of introduction, is to say that a particularly profound and deep issue is the disproportionate number of Māori in state care, and therefore the disproportionate numbers of Māori who have been abused while in state care. In 1989, through Poauta Atatu and the then legislation, we had the opportunity for a genuine revolution in the way we cared for children. Frankly, that opportunity withered on the vine very early. Now, in 2019, we have a second chance for the revolution that never materialised the first time. This is an obligation now on us to get it right a second time. The fifth thing to say, by way of introduction, is that in my view, urgent transformational change is required to the care and protection system. I highlight that, in my view, the time has come to appoint a separate statutory body, a Commissioner for Children in Care. Maybe two commissioners, at least one of whom must be Māori. There must be a truly independent monitor of the care and protection system, empowered where necessary to speak out publicly as a watchdog. There must be a truly independent complaints system. The systems that are in place now and have been in place have not been independent and are fundamentally flawed. There must be closure of the large-scale care and protection residences in New Zealand. They should be replaced by much smaller, family-based homes for 2, 3 or 4 children or young people, but as a temporary option and as a last resort. I'm not advocating we change a bad system to a less bad system. Wherever possible, if a child needs to be removed, placement should be with properly resourced, supported and assisted wider family or kin care. And the final point to make by way of introduction, point 6, is that I urge the Commission, with great respect, to exercise your discretion regularly and consistently to consider issues and experiences of those in care after 1999 through to the present day. I say that because it's often asserted there's a bright line in the past where abuse has stopped. No one can tell me when that date is. And while one hopes that the extent and depth of abuse has reduced. We know that it is still happening. Oranga Tamariki, and I commend them on this, are producing quarterly reports of abuse and neglect of children in care, which reveals a 7 to 10% current abuse rate. Frankly, that is likely to be the rock bottom number, because we know that the power imbalance for children in care inhibits making complaints. The actual percentage is likely to be greater, and we know from the Australian Royal Commission that it's about 22.9 years before adults make disclosures of abuse as a child. So please exercise the discretion liberally to go beyond 1999. So there are the 6 introductory comments and the summary of where my submission will go, and I'm happy to be led through those submissions that need further amplification.
Kia ora, Judge. Thank you for that. In terms of the first detailed point you make, you outline in your brief the role of the Office of the Children's Commissioner in terms of the monitoring function currently, and I know you've briefly outlined that in your introduction just now. Was there anything else in terms of the current monitoring role and under-resourcing that you wish to say at this point?
I think the submission is clear that we've got a widespread statutory mandate that's never been resourced or funded to match the legal mandate. We've talked a good game about monitoring. It hasn't been delivered, and to the extent that the office is implicated in that, that's admitted.
And as I understand it, the focus of the monitoring function the office can fulfil has been on residences as a primary point of focus.
That is correct. About half the office's operational resources go towards monitoring and assessment of Oranga Tamariki. In 2012, that was 2 staff and a director, soon became 4 staff and a director, now 9 staff and a director for 6,400 children in care. The decision's been made to prioritise those most vulnerable in state detention, you're right, in the 9 care and protection and youth justice residences.
And I'll just ask you, Judge, in terms of the pace for our stenographer and sign interpreters, just to keep an eye on them as we're going through so that they can capture everything. In terms of the point you outlined about a separate and independent monitor for children being so vital, could you tell us a little about the current state of play in terms of what was announced in April this year of the proposed changes to how that independent monitoring might work?
The Cabinet released a paper, you're correct, talking about a review of the monitoring and oversight systems for children in care and the complaint system. General big picture decisions were made, but the detail is being worked through now. An important point to make is that it would be important, in my view, for the government not to set in stone decisions about that monitoring and complaint system before it had had the full advantage of the Royal Commission's findings, or at least leave the door open for amendments to that new system pending your findings, because this really is a once-in-a-lifetime opportunity to overhaul the system, and what you will determine ought to significantly influence the new monitoring and complaint system that is being built.
And you've said in your brief that the intention of the review is to strengthen the independent oversight of children in the care of Oranga Tamariki. Has anything emerged thus far to show whether that intention will be realised in terms of the new proposal?
Yeah, no final decision has been made, but all the public communication has been that the government is committed to not just small increases, but a fundamental change in resourcing and oversight. I mean, calculations made by our office that to properly discharge the role, a staff of between 80 to 100 would be required, and a significantly bigger budget. But nothing less will do if we are going to take seriously independent monitoring of every child in state care. But the final decisions are still to be made. They're happening right now.
So that's 80 to 100 staff to do it properly as compared to currently, I think you said, 9 staff?
9 and a director. We're talking about a radical and qualitative change. And that, I might say, is not dreaming of a Rolls-Royce system. That's simply getting in place what is needed to discharge the statutory mandate.
So in terms of what else that might look like, you mentioned just briefly in your introduction a new role, a Commissioner for Children and Young People in Care. Could you tell us first a little about why you think that's so important?
It is a specialist skill set to know the legislation, policy and practice of the state care organisation. It is a significant and demanding role in itself. I envisage a Children's Commissioner and perhaps co-commissioners for children in care, one of whom must be Māori, working together under the same governance structure, in the same office, supporting each other. But I think the time has come, if we're going to prioritise monitoring, to have that specialist, focused, independent watchdog for children in care.
Structurally, you mentioned that that Commissioner and the Commissioner for Children could become parliamentary officers.
Absolutely. I think that should be the model. You know, there's a parliamentary commissioner for the environment so that the taonga, the treasures of our mountains, rivers and lakes are watched over, cared for and given a clear watchdog mandate. Surely our children are no less treasures than the physical resources. Why, in principle, would we not have a truly independent parliamentary commissioner for children? That is something, in my view, that needs urgent attention.
You mentioned earlier that a motif throughout this work may be the issue of resourcing. What are the differences in terms of how resourcing would function if the role was a parliamentary commissioner?
Well, at the moment, the resourcing comes through Vote Ministry Social Development. The Minister for Social Development and Minister for Children, the office has a close relationship with. I think it would be far cleaner and have a much greater appearance and actual reality of independence if that resourcing came from Parliament, from the Speaker's committee, so that it was crystal clear that this was an absolutely independent role. 23% of our population are under 18s, children. They don't have much of a voice, certainly not a vote. It, in my view, defies belief as to why we haven't had a parliamentary commissioner for children from the beginning.
And is it right that the other aspect structurally of being a parliamentary commissioner would be that there's no reporting line to a minister? It's the administration is done effectively through the committee, the Speaker's committee.
Absolutely correct. And there's always a tension reporting to the body that funds the watchdog, especially if the watchdog is speaking out about a closely related government department. It will be much better, in my view, to remove that structural tension.
And you've mentioned the need for Māori representation at that high level. Just so that I'm clear, is it your suggestion that the Commissioner for Children role would be a co-commissioner model?
And the Commissioner for Children and Care as well. I think for all that we have learnt and heard already and know about the New Zealand demography, to reflect the treaty and to reflect a true governance model, the time has come for that role, yes.
Could I move now, Judge, to the third heading in your brief, which is at page 6. This is the obligation to get it right, which you touched on earlier. The first point you made about whether children are in fact better off as a result of state intervention. Could you unpack that for us a little?
And in doing so, I'd want to highlight the primacy, the beginning point being both the Convention on the Rights of the Child and particular articles of that convention that provide an obligation for special protection and assistance for those who have been deprived of or removed from their family. A principled starting point, together with the treaty, it seems to me, is vital to assert. And as an aside, the Convention on the Rights of the Child, the Children's Convention, is not taken seriously enough across government in New Zealand. And as a signatory, it's time that we prioritised in all that we do careful application of the Convention. But as to your specific question, yes, on the evidence that we have currently for children in care, it shows a pattern of high health education needs, poor educational achievement, a high likelihood of criminal offending for children in state care when compared to the general population. There isn't enough information to show whether outcomes for children in care are improving.
And Judge, we had some evidence earlier in the week on Monday from Professor Stanley, and she gave evidence about the way the state assesses risk in terms of intervention and began to explore this idea that risks in terms of an individual or particular family or whānau were prioritised without as much thought being given to the risks of state intervention and the negative things that may come from even benign state intervention. I just wondered if you'd like to comment on that thought.
I agree, and I think that is the danger and the trap for every government and state intervention agency, to overestimate the advantages of its intervention and to underestimate the risks associated from that very intervention itself. It always struck me in the youth court, the number of boys who were remanded elsewhere, who were in state care, when they breached their bail, it was invariably for one thing, to run back to the very home they'd been removed from. So the pull towards the family of origin is incredibly strong and perhaps underestimated. And you mentioned earlier, I think, your suggestion that really the focus is first on supporting within a family or whānau or wider family with appropriate resourcing. Have I got that right? Absolutely, and what is more, it is now the new statutory mandate with the new Oranga Tamariki legislation. As from 1 July this year, no longer is the old child, youth and family mandate in place. That was last resort, intervene when there was a need for removal, almost evidence at the bottom of the cliff. The new statutory mandate is early support, assistance, intervention, wherever there's any risk of removal, to get in and prevent it. I mean, that is a great model. It's going to take a paradigm shift in the way the state agency has previously worked, but it is the right principle and it is now the law, and we will have to be vigilant to ensure that the necessary changes, the fundamental changes in approach, actually take place. In terms of this section of your brief, you also spoke a little about what the office has learned as part of the routine monitoring. Most recently, I believe, is the
2017-18 year. Did you want to share any of those points with us in terms of the current experience of those young people?
Given that we have focused in terms of our agreed performance expectation of those in the secure residences, the message loud and clear, especially for those in care and protection residences, is, in the words of one young girl there, it's a hard place to be happy. It is a difficult experience, especially for those who are there for a prolonged time, aggregated with other children from traumatic and violent backgrounds. It's not a recipe for enduring rehabilitation. It is a tough place. I have quotes in my submission from children, and it talks of some have talked about the self-harm and the attempts of self-harm that have taken place. I mean, that is not to say that the story is universally of those in state care residence negative. I mean, some talked about it saved my life, but the general theme following through is that it has been a hard place to be happy, and we have recommended that the state care and protection big residences be closed. But we come to that.
Just to finish off in terms of this section, you've mentioned just briefly the 4 reviews that are ongoing currently. And I understand they all have their own different timeframes of when they'll be completed. But what is your comment in terms of how those inquiries might inform the work that's taking place here at the Royal Commission?
They're all looking at separate issues. They have clearly different terms of reference. I hope they will be of significant assistance for the Commission. And indeed, the first of those reviews, the Oranga Tamariki internal review of the specific Hastings case, I understand is due for release at 3 o'clock today. So the first step in the instalment, which will be of assistance, is due for release in less than 3 hours.
We'll certainly keep an eye out for that at the time. Your next point, Judge Beecroft, you made at the beginning, given its importance, but I want to come back to it in some more detail, and that is the experience of Māori, both in terms of being placed into state care at higher rates and also experiencing abuse in care at higher rates. Could you talk us through your thoughts on this section?
The statistics are well known. In fact, there are similar statistics in terms of poor outcomes for health and education and child poverty. So this isn't simply a state care issue, it's a much wider issue. And in my view, it's impossible not to begin by recognising the enduring legacy of colonisation together with modern day systemic bias. And that's an issue for every decision maker in every government department throughout New Zealand. And I would have thought that the research and current understanding makes that unarguable.
In terms of modern day systemic bias, as you've put it, could you help us by way of examples in terms of your experience being someone who's worked in the system for many years of what that might look like practically?
It's easy to use a term like systemic bias or systemic racism. I think what is meant by that is the collection of individual decisions, often made unconsciously or with sometimes the best intentions, but when aggregated together, result in a pattern that disadvantages, in this case, Māori. I know from my own experience in a different forum in the youth court, there was a clear statutory injunction that in terms of Indigenous Māori children, that whānau, hapu and iwi be involved in decision making and be encouraged to develop their own means of response. I realise with some shame myself, it's as if I practised with a version of the Act that had the words hapu and iwi print out. It was effectively a full stop after whānau. It was seldom raised in court or developed, and I did not fully give full force to the power of the Act. And I think if decisions are made in the care and protection context that don't explore more widely whakapapa links, resources that are available within wider whānau, hapu and iwi, and if decisions are made that narrow the focus and exclude those options, and if they are made regularly, that may well be the basis of what you would call systemic bias or racism against Māori. It's an easy concept to assert, but it needs to be unpacked, and we all need to be challenged, because it's likely that all decision makers in New Zealand, not just Oranga Tamariki decision makers, are susceptible to that unconscious bias.
And you've pointed out in your brief that's something that has been well documented in multiple reports in the last 30 years, and you reference Puao Te Atatu in particular. What are your comments in terms of, I know you mentioned earlier, the full vision of the 1989 Act as informed by Puao Te Atatu hasn't been realised, but have any of those concepts or ideas filtered through in terms of the work that you've been doing?
I mean, I'd like to think that the clear statutory vision is before all of us, before our office too. I mean, it was a wonderful dream in 1989, a vision that was very clear. It wasn't just a dream, it was legislatively set out. It was a new way of doing things. As I say, that vision quickly withered on the vine, decision-making shrunk back into a state care-dominated model. Some of you will know exactly that experience. It almost became that which it was designed not to be. So as at now, the challenge is to give full life to that revolutionary approach, which ought to mean a huge reduction of Māori children in state care.
And just to skip ahead for a moment, you mention at point D that legislative change on its own is not enough, and there's been some reference to the new Section 7AA in evidence in this hearing. What are your thoughts on the significance of that particular provision?
Well, as a lawyer and a judge, perhaps I trusted too much in the power of the law in itself to change behaviour. The 1989 law and its subsequent experience gives lie to the fact that law automatically changes behaviour. The new 7AA provision, in fact, does no more than makes explicit what ought to have been implicit for 30 years. It could always be seen, I think, now as a damning indictment on 30 years of failure. I mean, 7AA shouldn't be touted as a brave new world and new section. It is simply basic treaty law put in place, and it makes very clear what should have been the case for 30 years. But I look forward to it, because if those new provisions are given proper life, there must be change.
And just on that point, we also had some evidence last week from Dr. Moana Jackson, who was also asked about Section 7AA, and he commented, this is at page 244 of the transcript, in relation to agreements in particular between iwi and Oranga Tamariki, that they are systemically flawed because they do not address the power imbalances which exist. They retain the power of decision-making with the Crown and do not acknowledge the right inherent in Te Tiriti or Waitangi for iwi and hapu to make those decisions. And is that in line with what you're saying, or do you have a comment on Dr. Jackson's evidence?
I agree, and in fact, for every government organisation in New Zealand, there is a question about devolution of resources and decision-making power to iwi and Māori organisations, not just Oranga Tamariki. But for Oranga Tamariki, there are a number of models or steps that could be taken, at the least, to devolve power to iwi so that they have the resources to provide care for their own mokopuna, their own tamariki. Another model is to go further and to have two divisions within Oranga Tamariki, one for Māori, one for non-Māori. A further and most radical step would be to have separate institutions, one for Māori children, one for non-Māori children. The point is that the current structure needs to be transformed. All those options, it seems to me, are on the table and decisions will need to be made about them.
Another point, Judge, that you've referred to in your brief is the experience of people with disabilities in state care. Just to go back to page 8 for a moment. And I just wondered if you'd like to talk us through your thoughts in terms of that part of your brief.
I can simply say this. In our office, we have had continued and clear urgings from the disability community that special attention needs to be given to the experiences of disabled people in state care because they are doubly vulnerable, not just because of their disability but also because of state care itself. And I have been challenged to make clear that with great respect the Commission should not treat lightly the particular challenges in state care for those who are disabled. And early research indicates, and relatively new research, indicates that is a significant issue.
You mentioned earlier your view around the closure of big residences, secure care and protection residences, and you just go into this at a little more detail at page 9 of your brief.
The office's Director of Monitoring and Investigations, Ms Liz Kinley, is here. She leads our monitoring work. The clear conclusion of all our monitoring and visits to the secure care and protection residences are they should be closed. I understand, at least informally, that that is the view of Oranga Tamariki, but I will not speak for them, and I look forward to Oranga Tamariki confirming how and when those residences will be closed. It is an old-fashioned model. It is, as young people would say, so last century, the model of segregating children from violent and traumatic backgrounds and then aggregating them together is inherently problematic and very risky, not least of which is the potential for bullying and abuse from other children and young people when grouped together. But the system is flawed, outdated, anachronistic, and it needs to go. Just as we abolished orphanages and borstalls, so these residences should be closed down. And they should be replaced, we have said, by much smaller, community-based family homes with specialist staff. But they should not become the default option. That's what I meant by saying we don't want to replace a bad system with a less bad system. They should be short-term, temporary, last resort, because what must be prioritised is placement within family, wider family or kin care that's properly resourced one-on-one.
And just so we're clear, Judge, we've heard a lot of evidence about some of the historic residences, but today, in 2019, can you just clarify which ones you're referring to? I understand some of them may be physically the same institution, but with a different name.
Yeah, well, there are 5 care and protection residences, one in South Auckland, one in Ipuni in Wellington, 2 in Christchurch, 1 in Dunedin. They're varying sizes, but can I say this? It has been encouraging to us that the residence known as Whakataka, South Auckland, has been already significantly downsized. It's a different institution. It's probably only limited to 3, 4 or 5 children or young people as an assessment centre, as a hub, and they are moved out very quickly to spokes, which are hub and spoke model, the spokes being much smaller community-based homes. And that's a positive step in the right direction, and long may it continue. In fact, quickly may it continue.
Chair, I'm just conscious of the time.
Yes, and I sense you're about to go on to page 11.
That's
So
right.
that may be a suitable time for the Commission to take its lunch adjournment.
Thank you.
Ms Spellman, please continue.
Thank you, sir. Judge Beecroft, I've turned now to page 11, which is the 4th detailed point in your brief. And I wanted to ask you about your suggestion of creating a child-centred complaints mechanism. And perhaps we could start with you outlining first what is the current process.
This section deals with the need for a truly independent complaint system. At the moment, in the residential context, the complaint system is dealt with by grievance regulations with grievance panels drawn from the community, the system being known now as Whare Mataramatanga. Essentially, it demands that and requires that the process be commenced by obtaining from the residents or a staff member a form to complete detailing the grievance. You can immediately see the flaw in a system which requires a child or young person to initiate the complaint with a staff member who may in fact be a colleague of the person being complained about. It is very clear that children and young people themselves see the system as inadequate because of that reason, and the proof of the pudding, sadly, is in the history. No, or virtually no, serious instance of abuse, neglect, or any form of complaint has been uncovered using that system. It has worked very well in terms of complaints about the operation of the residence, food, lost clothing, other issues of that magnitude. But sadly, after nearly 30 years of operation, that system hasn't been able to consistently uncover significant abuse or neglect that has usually come through other channels, often when the child or young person has left the residence. So, relying on the current process as it is, without independence, has proved to have been flawed and inadequate. For those not in residential care, there are limited opportunities to make complaints, and usually they are accessed through the social worker, which again may be the very person in respect of whom the complaint is about.
And so in terms of the process, at least within the residences, after accessing the form, it has to be in writing, is that correct?
Correct.
And what is the role of the grievance panel at that point?
Submitted to the residence manager for investigation internally, which we have pushed hard for there to be a standard practice, but there are still variations within residences, and if the child or young person doesn't like the result, then there is escalation to the grievance panel, who try to advertise themselves, try to make clear that they're available, go to the residences for meals to get to know the children, but by and large, to get to the grievance panel, you have to get through the internal process, through the manager, and be dissatisfied with the result. Everything we know about the power imbalance of being detained tells us that children who are vulnerable are going to find it incredibly difficult to make a complaint to begin with. But to ask them to jump the extra hurdle of making a complaint to the very system in which abuse may have taken place has proved just about an insuperable hurdle.
And historically, what has the role been, if any, of advocates to assist in the grievance process?
Ironically, the legislation makes it clear that advocates should be provided by Child, Youth and Family or Tamariki, the residents. But it goes on to say there is no obligation on them to fund it. So in the end, it's become empty, and it has relied on a series of voluntary advocates who have come and gone, and there's been no widespread, consistent provision of advocates. And it's a classic example of adults designing a system, say, well, children should have advocates. Adults agree with that, but as for who pays it, not our responsibility. So in the end, it's been something of a dead letter for 30 years and incredibly frustrating.
And you mention in your brief a new organisation, Voice Whakarongo Mai. What is their role?
Oh, I think this could be a game changer. It's designed to be a widespread advocacy service for every child in care. If this doesn't appear to be too conflicted a description, it's an NGO set up by the government, funded by the government, but an NGO free to be independent and grow and develop and be an advocate and supporter of every child in care to help children negotiate complaints, to stand with them and to be their mouthpiece, supporter and mentor. It is a terrific model, still in its early days, but we have high hopes for it.
And I appreciate that it's still in its early days, but is there some current advocacy work that advocates from Voice Whakarongo Mai are already engaged with?
Yes, they have started in the residences, and they're starting slowly but surely to cover the whole country in residences, and they are proving useful and developing long-term relationships. And at last, children in care are beginning to have access to someone who can help them and speak for them when necessary.
And so you've mentioned that Oranga Tamariki have made a commitment to develop a new child-centred complaints process. Is that to replace the current grievance process?
No, the grievance process will be amended and is being amended, and it certainly needs to allow an independent exit route for a complaint from the beginning. But Oranga Tamariki have made clear that they want a new, fit-for-purpose internal complaint system. And all power to them in terms of developing that. But it won't be sufficient by itself unless there is a separate door that complaints can enter and make complaints to directly that bypasses Oranga Tamariki. Frankly, I think everything I have seen in my various roles is that we should be wary of trusting government agencies to design complaint systems. That's the frank reality. I could go on and say because they're not independent, they're not fully funded, and they use the language of adults to say, well, it'll be a way of continuous system improvement. Well, that's great, but actually it's got to be child-centred, fully funded, and utterly independent, and children need to know that, and they need to be able to trust it.
Thank you. The other point in the section, Judge Beecroft, is the new thematic monitoring review that I understand the Office of the Children's Commissioner plans to undertake, what is the thinking behind doing that piece of work?
Let's go back to that complaints point, because I think there's one point that I just need to stress. There has been in one sense, understandable, if not commendable, determination to design a new complaint system through an adult eye, as if having a Rolls-Royce complaint system internally is going to solve it. Even externally, it may not solve it, because the real question is, unless you get a complaint to investigate, it doesn't matter much. We've got to be thinking about how do we create environments and systems that enable our most vulnerable children and young people, often detained in a situation of power imbalance, to complain. And that is why the Australian Royal Commission says it's 22.9 years on average before complaints are made. We should be wanting 22.9 seconds before complaints are made. And somehow we have to get an environment where the complaints can be made. Great having a good system to carry out the investigation, but we've got to encourage the complaints to be made at the time. So, what we're hoping to do next year, what we committed to do, and our Director of Monitoring is here, is we want to follow up and carry out a review of children and young people who have been in detention 6 months to a year later. Saying, now you're out of state care, now you're out of detention, now you're out of the residence, is there anything more you want to tell us? Are there things you can say now that you felt you couldn't say then? It will be a way of us testing and getting information as to whether indeed there is a power imbalance that has inhibited complaints. We want to give that evidence to you, give that report to you when we've got it. But we think it will be very helpful, and it will help you, and it will help us all to understand why it is that children may not make complaints while detained and in state care.
And Judge, the next point in your brief relates to the way that the Royal Commission interprets its terms of reference, which you mentioned at the beginning of your comments. What was your thinking behind your strong encouragement to take a wide interpretation of the post-1999 time period?
Not for me to be too strong about this, it's a matter for the Commission, but point 10 in the terms of reference, 10b, says that the inquiry may at its discretion consider issues and experiences prior to 1950, and in order to inform its recommendations for the future, the inquiry may also consider issues and experiences after 1999. In my view, there's no principled basis for drawing the line in 1999 as it was in the first place. I'm glad there is that discretion. Please, please, please exercise it in a large and liberal way, because, and this is the reason I asked for it, abuse is still happening. We know that. Even on the self-disclosed figures of Oranga Tamariki, it's between a 7 to 10% abuse rate, and it's likely to be much higher. It would be wholly, in my view, inappropriate, it would be unwise, and it would be sad if the 1999 31 December deadline was only rarely passed. I think there's every reason to think we'll get a lot of good information to inform good recommendations if we regularly go past 1999. I mean, I've said it as clearly as I can, it's a matter for you, but with great respect, I would urge you to use it wherever possible.
And in terms, Judge, of the work of the Office of the Children's Commissioner, has, in some of the reports that you've cited in your brief, has that been borne out in terms of more recent experiences of young people? The ongoing nature of those issues?
Exactly. I mean, we still hear the sad and harrowing accounts of both abuse by staff and abuse by other young people sharing the residence.
Just coming to the end of this section, Judge, and just wanted to give you a chance at this point if there was anything else you wanted to share with the Commission in terms of your encouragement as to where the focus should be in the next few years.
Well, that's an enticing invitation that I should exercise wisely. I mean, there are so many issues that I haven't mentioned and perhaps should have done. The continuing option to remand young people into adult police cells and solitary confinement must be considered in the structural sense a form of abuse. The remand to large-scale institutions, unnecessarily because there aren't enough smaller community-based homes, must be considered a form of structural abuse. The rather absurd two-witness rule of the Jehovah's Witness Church, a faith-based institution, in my view, both mangles biblical principles and fails to understand the dynamics of sexual offending. So there is a list of individual issues that I could raise. But in conclusion, I think what I really want to say is that nothing less than a genuine revolution in our approach to care and protection will do. This is the opportunity to bring that about. Most of us in this room won't get the chance again in our lifetime to do it. I hope that we grasp it. Incremental change won't do. In terms of Māori, the revolution is through devolution of power and resources. We need a specific and well-funded, truly independent monitoring agency with a designated Commissioner for Children and Care, co-commissioners. And as long as I have life and breath, that is what I will advocate for. You need to know again, I said, be wary of trusting government agencies to establish independent complaints commissions. Be wary of government agencies in establishing monitoring institutions that are independent. I mean, we know under the Official Information Act, an aid memoir was produced for us where government thinking had been that the monitor should be a government agent monitoring another government agency. I mean, it frankly defies belief that that would give not only public confidence, but also necessary confidence for children in care. I mean, we have to hold the line on utter, full and complete independence, where a watchdog, where necessary, can bark loudly and bark publicly. We know there's an opportunity at the moment in designing the new independent monitor to fully involve Māori, so it's designed by Māori for Māori. These are matters, while you are continuing in your Commission's work, that are happening at the same time, parallel. And I hope that reports can be issued in a staged manner that can feed in to what's going on now. Otherwise, the danger is the horse will have bolted and the stable closed, the legislation's in place, and you haven't reported back. We need an independent complaint system. We need the closure of our care and protection residences. I'm committed in this role to transformational change. That's my respectful challenge to this Commission also. Tēnā koutou katoa.
Ka nui te mihi i te rangatira tēnā koe. Chair, in terms of questions from Council, I have had indications from Ms McCartney, QC, and Ms Leaunga that they may have some questions for Judge Beecroft. I may just need to check whether that's still the case.
Thank you. Have you organised an order between you, Ms McCartney and Ms Leaunga? Thank you. We'll proceed in that order.
This is now an unusual experience for me. Normally I ask the questions.
Tēnā koe, Judge Beecroft.
Tēnā koe.
I'm appearing for the National Collective of Independent Women's Refuges in New Zealand, together with Zoe Lawton, who I think Your Honour knows. The Women's Refuge have an interest, obviously, in the placement of children and young people in homes where they can be, in places where they can be protected. They also have an interest in the impact of the violence and the recycling of the violence intergenerationally. And in relation to the questions I have for you today, your evidence, your oral evidence, has defined and clarified a lot of the areas, or a number of the areas that I was going to go to, and understanding that the revolutionary change that you are advocating is the closure of the state care institutions, the movement on a last resort and short-term basis to community-based units. And in that regard, I have a number of questions. In phasing out the big institutions, are you recommending to the Royal Commission, and have you given consideration to this, a timeline for the phasing out?
Yes and yes. Part of me thinks nothing less than a bulldozer would do tomorrow. The other part of me recognises as a responsible commissioner that there's got to be alternatives and other options in place. And that's a responsible thing to say. But as has been shown with the drastic downsizing of Whakataka Pokai, these things can happen pretty quickly. I would be very disappointed if by the end of next year they weren't all closed. That's very doable. And given the 1.1 billion injection into Oranga Tamariki, surely this is the sort of thing it should be spent on.
In relation to the last resort and short-term community-based units you've spoken of, is there a period of time in which you think a young person, have you considered this, would stay in those units?
I haven't exactly considered it,
Right.
but I know we've had examples of 9 months to a year and much longer in the current residences, and I'm certainly not thinking that long. But there are children and young people who come from such damaging and violent and volatile backgrounds that at least in the short term, specialist, expert, intensive care is required. It's a small cohort of young people. The previous commissioner felt there were, as a paediatrician, there were 200 or so children in New Zealand who had very high and very complex needs. And I think that's a useful starting point. But no, I don't have an exact month figure to give you as to how long it should be there. Suffice to say, even better is specialised one-on-one living arrangements and care.
And perhaps I'd be interested in your answer to this, with the provision for application to be made if that community-based unit care had to be extended. Application to the court, I'm saying here.
Yes, I think there should always be monitoring. You know, a great example that's just happening now in the youth justice context, Ngāpuri Social Services wanted to provide remand care for young people. I visited Mahuru in Kaikoi a couple of weeks ago. Interestingly, they were thinking originally of 4 or 5 bed homes for young people. They did the research, they did the thinking and said that is just so not appropriate. Much better to have one-on-one care. They now have a suite of homes throughout Northland where young people can go one-on-one with experienced, trained family caregivers and mentors to look after them. And that's a way better model. That's what shows what can happen when the community, and Māori in this case, are given resources and power to come up with their own options. That's a significantly better model, in my view, than anything that's in place now. We could do the same for care and protection.
Can I come then to the resourcing, as you're just speaking of, while we talk about whānau-based care, and this can sometimes mean a relative for a
Wider family.
line of family member, that person or persons, I understand your evidence, would still need to be fully funded for the care that they are providing to the young person.
Exactly.
Yeah.
And I think there has been a false assumption that that sort of care ought to be free, but stranger foster care is resources supported and paid. Actually, they should both get the same. There's no reason to differentiate. Wider, more distant family who may be ready and willing still will face a significant and unexpected financial burden and need help and resources, just as stranger foster care is entitled to. And that's been long, I think, a glaring and unacceptable difference.
Would the Commissioner for Children in Care, the role that you are proposing,
Parliamentary Commissioner, yes.
a Parliamentary Commissioner, let me use the full term, would that person or persons have the role of monitoring the whānau-based care, home care positions?
All care.
All care.
All care.
All right. All right.
Without reservation.
And in relation to the role of the supervisors, if you like, the monitors, they would require specialist training
Absolutely.
in order to get into that level of monitoring.
And coming from a background of understanding child and youth development, child and youth dynamics.
Yeah.
In our office at the moment, we've got a mixture of trained social workers, child psychologists, research teachers of learning and behaviour, speech therapists, youth workers. All that sort of expertise is required. But as I said, the tragedy is of the 6,400 children in care, we're only giving detailed attention to the 200 in the residence.
Of course, if we close the residences, as you've suggested, they could bring the focus perhaps wider because of the young people being in a number of homes.
Correct, but the 9 current staff and a director are not going to be enough to
Right.
visit in a comprehensive way all 6,400 in care. That's why we came up with the 80 to 120 staff and probably a 20 million budget. We've got to be realistic. That's the sort of figures that we're talking about to do properly what we have never done properly until now.
Putting on my role as acting for Women's Refuge, would you agree that support would be required for the carers so that they are protected in the role that they are undertaking?
Absolutely.
Because as you've told the Royal Commission, the young people they're looking after come from often very damaged, violent backgrounds themselves, and would want to ensure that that cycle of violence is stopped.
Correct.
Judge Beecroft, are you aware of, we heard evidence of it yesterday, of economic research and papers coming out of Oxford University about the benefits of putting the money in at the beginning and not at the end after the damage has happened?
I am, and I agree. And in fact, one of the reasons I took this job from my current job is everything that I'd seen as a judge was that all roads lead back to much earlier intervention. First 1,000 days, first 7 years were crucial times. And a brief summary of that evidence, I think, is while we can be effective in the courts, it's twice as expensive and half as effective as getting in earlier, particularly in the first 1,000 days, when it's half as expensive but twice as effective.
Thank you. Thank you.
Thank you, Ms McCartney. Ms Leonga.
Tēnā koutou katoa. Council's name is Miss Leonga, and I appear on behalf of survivors who have claims before the Waitangi Tribunal. The Commission would have heard from my senior, Mr Stone, over the last few days, and I just have a few questions on behalf of our claimants. Tēnā koe, Judge Beecroft.
Tēnā koe.
So, thank you very much for your evidence. It's a privilege to stand before the Commission and you today to ask these questions. Firstly, just in relation to the first page of your evidence where you note the systemic failings of the Crown and how these have impacted Māori, and that your office is implicated in that failure. You also mention how your office has not been fully resourced or sufficiently resourced to discharge its duty. Would you agree that these failings would amount to a failure on the part of the Crown to discharge its duties owed to Māori under the Treaty of Waitangi, taking into account the principles of good faith, partnership and active protection?
Yes, as part of a wider systemic failure, yes.
Thank you. And you also mentioned that successive governments have known about the lack of resourcing, and so they've been aware of what's going on, they've been aware of the shortcomings, they're aware of the statistics that you've mentioned today, yet despite these failings and this knowledge of the shortcomings, it seems that children are still being let down. Would you agree to that?
In substance, yes.
Yes.
I mean, every government, not that I'm here to defend governments, but every government's got resourcing decisions to make, but it's been crystal clear that this many children in care at any one time who exist, and our office is only being able to visit that many. That's been well known.
Yes. And given the known statistics that Māori are disproportionately represented in state care, you would agree then that Māori children in particular are being failed even more so?
Yes, and I think I've said in the opening paragraph of the submission that the brunt of this failure in state care has been experienced by Māori. My very words.
Thank you. You also mention in your evidence the Puao Te Atatu report and how the Children, Young Persons and Their Families Act 1989 has failed to live up to the vision of that report. In that report, Māori speak about wanting more of a role, more of a say and more responsibility in regards to their tamariki. Would you accept that one reason the Act did not live up to the vision of Puao Te Atatu, and acknowledging, of course, that there are potentially other reasons, but that racism in particular played a very large part in Māori effectively being sidelined?
Yeah, that's probably unarguable as a contributing factor, as I confessed myself. I mean, the sort of unconscious bias and racism. If there were more Andrew Beecrofts, let's say, in that youth justice system, add them all together, and the collection of decisions accumulated results in a systemically racist system, as it may well do, and probably certainly does for every other government department faced with making decisions.
Thank you. And so today, here we are, 31 years after that report came out. The same issues have not gone away, and again, they're at the front of social conscious. Would you agree that including Māori in a far greater capacity and involving Māori more in decision making than has previously been done, that could go some way to assist change and to implement what was envisioned by the report?
Yes, absolutely. And in fact, I'd add, what you suggest is no more what the law said then and says now, to involve whānau, hapu, iwi and wider family in all decisions. I mean, there are 32 times in the new legislation when the phrase whānau, hapu, iwi and wider family groups are used collectively as being both the decision maker, those who receive the resources and are empowered to provide support and bring about rehabilitation for their own children and young people. But you could go much further, as I talked about. full devolution of power to iwi and Māori organisations, 2 twin houses within the same organisation, Māori, non-Māori, and one model, it's for others to decide, is 2 parallel care and protection system, one for Indigenous New Zealand children, one not, reflective of the treaty. In fact, you could go much further than what you just suggested.
Absolutely, thank you. And lastly, you've mentioned oranga tamariki in your evidence, and we know that oranga tamariki in particular, with a lot of recent public pressure as well, have begun to work more with Māori, which is a good thing and a step in the right direction. In your opinion, however, why is it that that seems to be the exception and not the norm?
Well, for 30 years it was the exception, contrary to what was implicit in the legislation. When you ask a massive question that is bigger than just oranga tamariki,
Yes.
the answer for which relates to why there are the absolutely inappropriate, disproportionate figures in health and in education and in youth justice and adult justice and life expectancy and rheumatic fever. I mean, they are the big questions for our country. This Commission, in a sense, is facing in this inquiry one of the big and intractable questions that we have as a country to grapple and to wrestle with, and that is the position, the disproportionate disadvantage of Māori and the brunt of all the negative statistics that they are facing. This is just but one instance of a much wider issue, but it can't be escaped and it can't be avoided.
Absolutely. Thank you for your time, Judge.
Thank you.
Thank you, Ms. Leonga. Judge, I'll now invite my colleagues, or as many of them that wish to ask you questions of their own. Might I begin with you, Dr. Erueti?
Tēnā koe, e tarangatira. So it is a real concern, isn't it, that your resources are devoted towards the residences, and so foster care and these other arrangements of care are therefore outside of the scope of your work, in effect.
In practice, that's
Yes.
correct, yeah. We keep an eye on the trends and we keep an eye on the principles, but in terms of visiting and supervising and interviewing and supporting and hearing from those children in those other forms of care, you're right, that is outside our practical scope.
Okay, thank you. And I understand Voice is providing an advocacy service for these children, but it seems, and that's an NGO, although it's also funded by the state, but it seems that also there's an advocacy role that's been established by the MSD, and so is that the case? And in fact, there seems to be some duplication there where you've got 2 services being offered.
The current grievance panel regulations for 30 years have provided for advocates for those in lock-up residences, but with no obligation, as I said, to fund them. I see it as inevitable that a growing and properly resourced Voice Whakaronga Mai will take over all those advocacy services, and that's the dream based on a model from Scotland. It was a key plank of the expert advisory group's recommendation back in 2016 that looked at child, youth and family services. Voice got off to a slow start, but there's every reason to believe that it will deliver a much needed advocacy service that's been a hole in the system, and it's inappropriate conceptually for the monitor to also be the advocate.
Yes.
So to have a separate advocacy service is just terrific, and it's long overdue, and it's what's needed, and we support it.
Thank you, sir. And we heard yesterday too about the need for targeted specialist services for those who are in care, not just the more general sort of services that are provided to children. And that seems to be a major gap in Aotearoa today. Would you agree with that?
It's a significant gap, yes. And I think for those 200 or so children and young people with very high and very complex needs, I think it's easy to underestimate the depth and the extent and the profound nature of those needs, and they do need some very significant expert, well-resourced services. Too many of them really have been failed by education and health systems as well. One thing I'd urge is that we broaden the discussion and not simply have oranga tamariki, as it were, left literally holding the baby. Health and education have to be there too, and there are children now in the care and protection residences who actually should be under the health umbrella, and they should be provided with humane, compassionate, expert health intervention. We've allowed a system where oranga tamariki has really become, in some sense, and I use this not callously, the dumping ground for the very most challenging children and young people. And it's not fair just to say it's oranga tamariki's problem. It's not. It's much wider than that. And I hope you hear from health and education services as to where they are in all of this.
I just want to clarify that your vision is of the Children's Commissioner having, that would also have two co-commissioners, your current office, and then there would also be a specialist care and protection for children
co-commissioner,
two commissioners as well.
I think so, yes.
There's been a call recently for a Māori commissioner to be an officer to be established. I just wonder what your views were on that.
Well, I can give you a stop press update if you want. The most that I can do under the current legislation is to appoint an assistant Māori Commissioner for Children. That sounds a bit of, in my daughter's terms, a debuzz, but it's the most that I can do, and it's not meant to be disrespectful. And we're appointing a chief Māori advisor to help us with the job specification. We'd like to appoint one by July next year. So we're doing all that we can within the office to try to reflect a treaty approach to our structure, and we're committed to that, and I look forward to the improvements that will bring. But I think ideally having two commissioners, you could say at least one of whom should be Māori in a co-commissioner role, I think that would be an exciting and creative way forward that's never been attempted in New Zealand before. But that's what I mean by radical transformation and structural change.
Judge Shaw.
Thank you very much for your evidence. You must feel as though you've been beating this drum for a very long time.
As with others, but yes.
Indeed. And one of the drums that I think you have been beating, and you've referred to it briefly, and I'd just like a little bit more detail about this, about the limitations on the Office of the Children's Commissioner due to under-resourcing. And you just note on bottom of page 3, these limitations have been frequently drawn to the attention of the government of the day by successive children's commissioners. This is not to question that that is true, but one of the things that we are looking at right across our terms of reference is what did the government know and not act on? And so to that end, I'm asking you, are you able to give us a little bit more information about the way in which these failings have been reported to successive governments by all the commissioners who've come before you and yourself?
For myself, and say that I have said as at now 6,400 children in care. We haven't got the money to visit them all. Where do you think the priority is? We have, as all commissions do, a specific performance expectation signed up. It was agreed that we would focus on those in detention because they were the most vulnerable and who operated most beneath the radar. And at the time there was the Australian controversy of revelations of abuse current in Australian youth detention centres, and we thought at the very least we've got to go in, and we visited each residence twice for 3 days in each year. Now, that was done well humanly speaking, I think, as could be done, but it still left the other 6,200 children without independent visitation and interviews. Yes, they had their own social worker, yes, they had access to support and services, but It was the reality. I mean, if you take an example, I had a chance to see British Columbia when I first got the job, roughly similar population, similar issues in Canada. No, there were 60 staff there and a budget of 20 million, and that was just seen as the basic infrastructure that was required. And I came away thinking, how far short are we in New Zealand? How can it be?
Sure. So you've been thinking about it undoubtedly. You've been doing as much as you can within your resources. What I'm really trying to nail you on is, in what form did you tell the government this? I mean, we've heard you on Morning Report. We've heard you
Face-to-face.
Face-to-face in written reports?
Yeah, in written, I've got my, yes, the nod. We
Yes.
produce annual state of care
Right.
reports. I know the previous Children's Commissioner, paediatrician Dr. Russell Wills, he did too, because I checked with him.
And that's really what I'm getting at. There's no way in which a government of the day could say, we didn't really
I know
understand.
there's science-specific performance expectations. They knew what we were monitoring and what we weren't.
Yes.
Absolutely. I mean, it's a matter of public record. I'm not blowing the whistle. It just was what it was.
That's really what I was looking for. My second question is one that may well be picked up by my other colleagues, but I'm just interested in the existing legislation, the now Oranga Tamariki Act. It sounds from what you've said to us that you don't think there's a great deal wrong with that, except perhaps, as you said in answer to Ms. Launga, perhaps the need to devolve to Māori more. But just taking the Act as a whole, do you think it is currently fit for purpose? Are you in a position at this stage to say that, or do you think there's something that needs significant and urgent attention?
It's a good question. The first comment is I've always thought, maybe too much the language of a lawyer, that it was quite an inspirational act and was well worded. The issue has never been with the words, it's been with the practice. And even in terms of devolution, Section 7AA strongly hints at that in terms of the Chief Executive being able to receive applications for new initiatives and new ways of doing things. And the Mahuru Remand Service, small but significant step, is an example of that. So I think the Act enables much that has never taken place, but much that could take place. And it's been seen, I think rightly, as quite a principled and visionary piece of legislation that has fallen down woefully in the practice as far as Māori are concerned in particular.
Yes, I thought that was where you were going, and I think that probably is. So it's the way it's been implemented, it's perhaps the racial undertones that are going through the interpretation, the overlooking of those that is the issue, rather than the substance of the Act. Correct?
Yes.
Yes. Thank you so much for your evidence.
Well, I could, if asked, certainly come up with a wish list of amendments, but fundamentally it's in sound shape.
Yeah. Thank you.
Thank you, Judge Shaw. Mr. Gibson.
Thank you, Judge Beecroft. Welcoming your welcome of the challenge from the disability community, and you made a comment about research. Is that, again, describing some of the problem, or is part of is there solutions coming out of that research which fits into your vision of transformation?
Yes is the answer, and I simply rely, and it may have been a report during your time with the Human Rights Commission, 2017 research, looked at a small slice of 18 disabled children, but that was a pretty damning revelation of what was going on for them. I think the answer to my question is more research needs to be done, but I simply wanted to plead with the Commission that we don't overlook the particular needs of the disabled community, because in general their needs are often overlooked, and they were doubly at risk when placed in state care, it seemed.
And almost a parallel question about is the system systemically racist? I would ask, is the system systemically ableist? But there's almost a preceding question to be answered. Is ableism understood so deeply entrenched in the system that it's not noticed, it's invisible?
Probably not an area of prime expertise for me, but so far as what you are saying goes, I accept it. But it's a much more community-wide issue, isn't it? That all of us are probably to some degree unconsciously ableist.
Also, to what extent, you talked about health education, to what extent are solutions, transformations tied up in a more joined up whole of government approach to try and deal with intractable issues?
Totally, completely and utterly.
And a monitoring regime that monitors children in care, could that respond to the complexity of cross-government issues? Or how would it do
and
that?
indeed the Cabinet paper specifically indicates that the monitoring system has to be wider and has to monitor, and it mentions health and education as services that are provided for children in care. And it can't be a mono-focused monitoring of just Oranga Tamariki. It's got to be, I think, whole of government. And that's one of our current failings in the legislation, the Children's Commissioners Act. It doesn't explicitly give us the power to monitor health and education, and I wish we could, because so many of those in care are out of education and have had long-standing unattended health issues.
A specific question about neurodisability, that the extrapolating the international research to New Zealand, it indicates that probably 70 to 80% of children in youth justice have neurodisability. What's your sense of the scale of the issue and the solutions in Aotearoa, New Zealand?
I think at the moment we see through a glass dimly, as it were, regarding neurodevelopmental disability. We haven't taken it nearly seriously enough in New Zealand. I mean, dyslexia was only recognised in 2006. Autism became liable to disability support services in 2011. Fetal alcohol spectrum disorder could be one of the great crises of our time, but we're simply, I think, sitting on our hands largely on that issue. And we had a 4-year FASD action plan that was high on plan but very low on action. I think we don't have prevalence studies of FASD or some other issues. I think we simply don't know the scale of the issue. But I do think, and I say this carefully, that there is a strong argument that we have placed in care and in prison a cohort of young people and young adults whose real issues are undiagnosed neurodevelopmental disabilities, and history will judge us harshly because of it.
Kia ora, thank you, Judge Beecroft.
Thank you, Mr Gibson. Ms Lofivai.
Thank you. Good afternoon. Talofa lava, Your Honour.
Talofa
Very
lava.
lovely to be in a position to be able to ask you questions this afternoon. As you well know, I'm very interested in the system and the system's blocks, and I was really wanting to just understand and get it on the record that when you're talking about transformative change, because it's easy to look at things in silos, and so I appreciate the parameters of your brief in terms of the OCC, but a child does not grow up in a vacuum, grows up in a whānau. So we're talking about from the moment of inception, following them through the different milestones in their life, to be able to get to the point where I think it's Crockett says it's 25 is the age that they age out of the system, making sure that the dots actually connect to truly give them the priority that we often talk about but we don't deliver on as a nation. Is that correct?
I agree with you.
Yeah.
I know of your concern and I agree. In fact, just as a small aside, with fetal alcohol spectrum disorder, we'd be going preconception and being much clearer as a country about the risks of any alcohol consumption while people are behaving in a way that may lead to conception.
So despite best efforts in terms of research, its availability, but also evidence, and actually just what families and young people are telling us, we still haven't been able to do that well enough to get even to almost like where we feel like there's a transformative change happening.
I mean, there's been progress towards coordinated, joined up interventions. Would be wrong to say it hasn't happened, but it's been incremental.
Yeah. And that's not enough.
Correct.
Yeah. And so the other point is around diversity and inclusivity. So thank you very much, and we appreciate the statistics around Māori and the damning impacts on Māori children. But what we also know is that there are a lot of children of mixed heritage coming through, Māori Pasifika, Māori Pākehā, Māori something else.
Yes.
And were you seeing some of those in your work in terms of trends around children of mixed heritage in the care system? And how can you offer us a perspective on maybe some numbers?
Actually, on data as a whole, I think that's one area that should be of interest to the Commission. The old Child, Youth and Families data was very patchy. Dr. Russell Will's previous report on state of care said there was very limited outcome data. I think one of the challenges for Rangatamariki, which it is trying to meet, is produce regular, unarguable state-of-the-nation statistics on all the things that you're talking about and the data. But for instance, we know when there are 67% of children in care who are Māori, some of those, about 9%, are Māori Pasifika. So it's important to unpack the statistics, but there's never been clear statistics available. Even now, when you talk about removal of Māori babies, different time periods are taken, sometimes 0 to 3 months, sometimes first 7 days, sometimes first year. It becomes very confusing. I think we need a clear data set, particularly for all connection with children in care. That should be designed with, but not solely by, Oranga Tamariki. And that's something we've been trying to do.
And of course, another group of young people that fall within our terms of reference are those that apologies. Of course, another cohort of young people that fall within our terms of reference would be those in the LGBTQI community. Any comments around some of those young people that you've seen in care?
No, only that those I've met personally talk more about bullying and marginalisation, or being bullied and being marginalised and alienated, yeah. More than I had realised, actually.
And obviously, in terms of possible solutions, different matrices to be able to work out actually what would work better to keep them safe, yeah.
Correct.
Yeah. I'm really interested in the vulnerability of our young people is really embedded in the legislation. So they say you've got this act, you've got to do this work, but they don't fund you to do it, all right? And 7AA, like you said, it's almost like an indictment for us as a nation that we had to physically write it in, you will consider the Treaty of Waitangi. We've now got kids that are transitioning to independence, that are coming out of care, and we've got Section 386A, which of course is still a work in progress because it means that those who have been in care or rangatamari care are still responsible for them up to the age of 25. But when we talk about the practice implications, this is where the variability comes in. Have you had any experience or any young people discuss that with you or your office?
That is Ms. Kinley, Director of Monitoring and Investigation, who's giving unsworn, unaffirmed, helpful comments to the Commission, but the gist of it being too early for us to say yet, because it was 1 July that took effect, and we're now only 3 or 4 months in, but glad you're here, thank you.
Thank you for that, but already we're hearing noises around how that is actually not serving some young people well already. And I was just wondering if your office had...
Too early for us to say.
Okay, thank you. No further questions from me. Just very, very grateful for outlining your big picture and where you think we should be going to as a nation in this area. Thank you, sir.
Thank you.
Judge Beecroft, I've got 3 aspects of question. Number 1 relates to your challenge, your wero, to the Royal Commission to use the discretion in the terms of reference to look at items post 1999. At page 3 of your written brief, you speak of Oranga Tamariki today servicing 30,000 people, with 6,400 in care, and you speak of these 200 high needs people. Are you able to give us something of a picture, seeing that your office will be 30 years old shortly, 10 years ago and 20 years ago, how that has that 30,000 figure grown exponentially over that time?
I think it best that we give you an addendum written response to that and the figures. But I know, for instance, that above that 30,000 are reports of concern. Now, as is known, they have increased significantly. Numbers in care have also increased. Whether it's exponential or gradual on the graph, we can provide that information for you.
Well, I think I speak for all of my colleagues when I say that will be helpful, because we will, of course, consider this matter of going beyond 1999, but we'll need the figures to do it.
Yeah, well, certainly the numbers in care after 1999 have increased, the raw numbers, and they've increased significantly lately, some of which will be due to the increase in the age jurisdiction for the service. But yes, numbers have certainly increased in children in care.
Thank you. My second question is related to your strong submission made to the effect that the Children's Commissioner ought to be a parliamentary officer, funded by Parliament and responsible to Parliament, in the same way as the Ombudsman and the Clerk of the House and the Auditor General, and as you referred when speaking, to the Parliamentary Commissioner for the Environment. You will know that those officers of Parliament receive their funding from an appropriation by Parliament. In other words, there is no cabinet resolution that results in their remuneration. Do you think it would be a disadvantage for the office of the Children's Commissioner not to have a voice at the cabinet table supporting the efforts of the Children's Commissioner?
That's a penetrating and deep question. I would still have thought that the relevant ministers whom the Commissioner monitors would want to have a view as a cabinet, but in the end, I think it's cleaner and purer for the Commissioner, the Parliamentary Commissioner, to make a case for sufficient and necessary independent funding. And I still think that outweighs the disadvantage, perhaps, that you bring up.
Yeah. In other words, you're saying that you think that the Parliamentary Commissioner that you have in mind would be able to make submissions to the relevant Parliamentary Select Committee of a sufficient kind that would ensure the whole of Parliament agreeing that the funding for the Children's Commissioner should be sufficient to undertake his or her job?
That's what I would hope. Because it seems to me one of the big dangers is that when you have an independent statutory watchdog, inevitably you are forced sometimes to bite the hand that feeds you. And it's much better that you're fed and courted and housed by the whole of Parliament, because children should be a whole of Parliament issue. And it's potentially, at least and theoretically, too easy to get offside with the government of the day if the watchdog barks in a way that causes embarrassment. for instance, about child poverty.
Thank you. My third question is related to Puo Te Atatu, and we've heard almost every day in the public contextual hearing about the 1988 report and about how what it said in such clear terms was not taken up, and it remains just lying there 30 years on. Do you think that Puo Te Atatu is fit for purpose and capable of being reconsidered now?
Yes. But I should also add, much of Puo Te Atatu found its way into the 1989 legislation. So in a sense, it performed and still performs and still speaks by the fact that many of its recommendations are now legislatively enshrined. I go back to your question, ma'am. The legislation itself is fundamentally, in a principled way, sound, amongst other things, because of Puo Te Atatu, that doesn't sit on the sideline, but it's pretty much enshrined in legislation now. But the answer to your question is yes. There is room to do that.
So Puo Te Atatu could be reconsidered as the Royal Commission does its work?
I think so. And why it's mentioned by so many people, particularly Māori, is it's seen as still speaking.
Thank you. I hope I make obvious my colleagues in thanking you for the clarity and the breadth of the submissions you have made as Children's Commissioner. They will undoubtedly be very, very helpful in our ongoing deliberations. I want to say also that this may not be the first time on which you will be giving evidence at public hearings of the Royal Commission, because there may well be further matters as we come towards later aspects of the Royal Commission's life where what you might say will be helpful to us. Thank you.
Thank you. Could I add one addendum, just for the record, to Commissioner Shaw? You asked about speaking to government about this many children in care, but only being able to monitor this much. In fact, the Cabinet paper is a response to that very concern that was raised. In fact, that was heard. What is planned is a pretty gigantic change that does show there was 2 ears hearing it and action promised in the Cabinet paper. And it's, I think, responsible of me to say that. Of course, we wait to hear the decision.
Oh, thank you for that. It just took a little while, didn't it?
Yeah, about 31 years.
Yes. Thank you.
Thank you.